So when we talk about trademark strength, we're essentially talking about how distinct your mark is. And there should be a kind of preliminary analysis done by your trademark attorney before you even file your trademark with the USPTO. And essentially, there's 5 categories where your trademark will fit into. And these are categories that were created by a court in a federal case. And the 5 categories are generic, descriptive, suggestive, arbitrary, and fanciful. And what you don't want is your trademark or your brand name to be in the generic category or the descriptive category, but you'd rather want it to be in arbitrary or fanciful. So if your mark is generic, this is usually a common name for a product or service that you provide. For example, if your mark is knife and you're selling chef's knife, or if your brand name is lawyer and you're providing legal services, this would not be protectable with the USPTO, and you can't even register it with the USPTO. So that's what you don't want, is you don't want your mark to be generic. The next category is descriptive. This is a trademark or a brand name that describes the product or service or a characteristic of the product or service that you're providing. For example, if you're selling batteries or your brand name is selling batteries and your brand name is long-lasting battery, or if you're providing a delivery service and your brand name is called Speedy, then this may be protectable with the USPTO, but not very strong. And you'll have to show that your brand name or your mark has been used for a long period of time and you've spent a lot of time and money marketing it for you to acquire this distinctiveness. So it's very difficult to do, and it's suggested you don't kind of have a brand name that would fit that category of being descriptive. The next mark or next category would be suggestive. This is something that kind of describes or suggests, I should say, not describe, but suggests an attribute of your product or service without actually describing it. So suggests an attribute without actually describing it, where imagination or some sort of imagination is required to determine the nature of your product or service. For example, if you've got a garlic peeler and your brand name is No Tears, then that kind of takes a little bit of imagination for the consumer or the public to kind of connect the dots and say, okay, well, they're selling garlic peelers and their brand name is No Tears. Or if you got PPC optimization software and your brand name is ACOS Bully, then that would also kind of fit into the category of being suggestive. These are registrable with the USPTO and protectable, but again, kind of weak. The category that you want your brand name to kind of fit in is going to be arbitrary, which is next category we're going to talk about, or fanciful, which we'll kind of discuss in a minute. So arbitrary, this is a real word, but it's used in a way that's not commonly connected to the actual meaning of the word. For example, Tesla for automobiles or Apple for phones and computers. These are always protectable and always registrable with the USPTO, and these are considered strong marks. So again, Tesla is a real word in the US dictionary, but in this case, it's used for automobiles. Or Apple, it's used for phones and computers. We all love our iPhones. I'm actually recording this on an iPhone right now. So that would be considered arbitrary. However, if we got the brand name Apple and we use it for our brand which sells actual apples, then that would be considered generic or descriptive and wouldn't be a weak one. So here in arbitrary, we're kind of taking a real word and using it in a different way. So you could have your brand name kind of be in that category, and that would be a strong mark. Now, kind of the best place you want to be as far as your mark strength, your trademark strength, or your brand name strength is going to be the category of fanciful. This is a name that's been kind of made up, or a phrase that's been made up. For example, Cisco for networking equipment, or even our law firm ESCO for legal services. Cisco, if you guys don't know, is actually the last kind of few words taken from San Francisco, which is where the company was founded or created. So that would be considered fanciful because it's a made up word. Or ESCO, our law firm, it's essentially we took ESQ, which is short for Esquire, and another word for attorney or lawyer, and we added the word go to it, and we kind of put those two words together and we got ESCO. So these are considered very strong marks, and they're very protectable and always registrable with the USPTO. So just something to consider when you guys are creating brand names for your products or services is make sure that, again, they fit into the category of arbitrary or fanciful, and always stay away from generic or descriptive. Okay.